for Edmonton to court.
Thank you, Mr. Speaker. I'm pleased to rise and contribute to the debate on Bill 204, the Traffic Safety Distracted Driving Demerit Amendment Act 2014, sponsored by the Honourable Member for Calgary East. I would like to thank the Honourable Member for being a strong advocate for promoting road and traffic safety and responsible driving. Mr. Speaker, it is important to Albertans to understand that approximately 25% of all collisions involve driver distraction, and anything we can do to help change serious or risky distracted driving behaviours will have a tremendous benefit. Driving in the province of Alberta is a privilege and not a right. The research speaks for itself, Mr. Speaker. Distracted driving is a form of impaired driving, as a driver's judgment is compromised when they're not fully focused on the road. A driver who is distracted is more likely to be in a crash than drivers who have two hands on the steering wheel, Mr. Speaker, and eyes focused on the road. We need to discourage distracted driving and to reduce collisions, injuries, and fatalities resulting from this type of behaviour. Mr. Speaker, if passed and proclaimed, Bill 204 would amend Section 158 of the Traffic Safety Act by adding the following after subsection 4. I thought it would be of interest to review what actually the bill states. It states a person who is guilty of an offence under Section 115, subsection 1, titled Cellular Telephones, Electronic Devices, etc., 115, subsection 2, display screen visible to driver prohibited, 113, global positioning system, or 114, prohibitive activities. Also, it includes A, is liable to a fine of $250, and B, shall be assessed 3 demerit points in accordance with the regulation. Currently, the penalty for distracted driving is a fine of $172, and offenders are not penalized with demerit points. Anyone wishing further information in this area can refer to the Provincial Offences Procedure Act Procedures Regulation. Also, it's important to note that in Alberta, drivers that exhibit what is deemed to be a more serious or risky driving behaviour could be charged with driving carelessly under the current Traffic Safety Act. The penalty for the existing driving carelessly offence carries 6 demerit points and a fine of $402. As we debate Bill 204, we should consider examining the issue from other jurisdictional perspectives. For example, in June of 2014, the Northwest Territories Department of Transportation almost tripled the fines for distracted driving from $115 to $322, which includes a 15% victim of crime surcharge. In Ontario, the provincial police have indicated that distracted driving is the #1 killer on their roadways. In that province, it is against the law to operate a handheld communication and electronic entertainment devices, which include iPods, GPS, MP3 players, cell phones, laptops, and DVD players, while you are driving, and to view display screens unrelated to your driving. If you break this law, you could receive a fine of $225 plus a victim surcharge and court fee for a total of $280 if settled at a court, and a fine up to $500 if you receive a summons or fight your ticket. Although the province of Ontario has seen success with their distracted driving law and public education efforts, the Legislative Assembly of Ontario recently referred Bill 31, the Transportation Statute Law Amendment Act, making Ontario roads safer, to the Committee for General Government. Highlights of the Making Ontario Roads Safer Act include increased fines for distracted driving from a current range of $60 to $500, upward to a range of $300 to $1,000. This would become one of the highest fine ranges in Canada for distracted driving. In addition, it was proposed that regulatory changes would apply 3 demerit points and add a distracted driving prohibition to the existing graduated license system driver's license conditions. In October 2014, the province of British Columbia traffic violations are under the heading Careless Driving Prohibited, Section 144, where it states in subsection 1, that a person must not drive a motor vehicle on a highway, A, without due care and attention, B, without reasonable consideration for other persons using the highway, or C, at a speed that is excessive relative to the road, traffic, visibility, or weather conditions. Also, it includes subsection 2, which states a person who contravenes subsection 1A or B is liable on conviction to a fine of not less than $100 and subject to this minimum fine. Section 4 of the Offence Act applies. A driver found of using a handheld electronic device while driving may receive a $167 traffic violation ticket that also carries 3 penalty points, Mr. Speaker. Offences and infractions that include penalty points will remain on a person's driving record in Ontario for 5 years and can lead to further penalties, including a driving prohibition. Stricter limitations are also imposed on drivers in the Graduated Licensing Program, GLP, as risks are demonstrated to be higher among new and young drivers due to a combination of inexperience and a tendency toward greater risk-taking, and significantly higher than average use of electronic devices, and all combined makes this group of drivers particularly vulnerable. Mr. Speaker, these examples demonstrate that legislators are taking a renewed, active interest to fight the problem of distracted driving head-on. Distracted driving is both dangerous and intolerable. Many have initially hoped that education and awareness campaigns against distracted driving would result in changing driving behaviors. In many cases, it is too early to determine whether increased severity and penalties will have the desired effect in jurisdictions that have adopted such measures. But what we do know, Mr. Speaker, is that demerit points are a far more onerous penalty than mere fines. As such, there is good reason to believe that adding demerits as a penalty may be a far more compelling deterrent for distracted driving. Mr. Speaker, the increased penalties proposed by Bill 204 simply reflect a broader intent and a broader trend that has been occurring in other provincial jurisdictions. It is clear that the honourable member for Calgary East believes that we should, and he makes a very strong case for the change. Mr. Speaker, thank you for the opportunity to add to the debate. I support Bill 204 and look forward to hearing alternate perspectives. Thank you.